Since 2022, we have been sharing details to keep members informed about the legislative changes and impacts of Bill 41 and the resulting legislation, which has introduced new requirements and responsibilities for both employers and the workers. In the past, this January, these requirements went fully into effect, and we brought in many representatives from WorkSafeBC, KSW Lawyers, and TeksMed Services to help answer many of your questions. Today, we've invited these experts to return and talk to us about return to work, disability, and employment law to discuss the outcomes and lessons learned and the impacts that these regulatory changes have had. When we sat down to discuss how to organize these sessions, we saw some common themes and issues. So before we go into those question-answer panel discussion format, we've asked each of our guests to take a few minutes to share some common concerns and questions they have heard from employers and workers. So let's introduce our panel. So first, we've got joining us today, Teresa Cheung from WorkSafeBC, Return to Work Services, Consultation and Education Division. We have Chris Drinovz, an experienced employment lawyer in Abbotsford, well, I don't think he's in all of these places, but offices in Abbotsford, Langley, Surrey, and South Surrey, and is a partner of KSW and the head of employment labor group for KSW Lawyers. And we've got also Amanda Peck from TeksMed Services, a company specializing in helping simplify disability claims management and everything around it for employers. So welcome this morning. So maybe to start off, we'll have Teresa take it away for us.
Thank you so much, Wayne. I'm really happy to be here with Safety Alliance again. It's been a little bit of time since I first visited with all of you. One of the question that was asked of us is to talk about some of the main concerns that we are seeing here at WorkSafeBC. And what we find when we're talking to employers is that a lot of employers, a lot of companies do have injury management programs, and they are doing a lot of the things that they're supposed to do. However, it's not always communicated to WorkSafeBC. So one of the things I wanted to talk about today and to share with you today is ways to contact us. We know sometimes it's difficult to get in touch with a claim owner or a person at WorkSafeBC. So I want to give you some alternatives today that will help you when you're communicating if there's a suitable job offer, when you're communicating if a worker refuses to return to work, or if you're communicating why you had to release someone from employment. I'm going to show you a few options on how to do that. And so I will share a small PowerPoint with you today so that you're able to follow along with me. Okay. So basically, I want to talk about through the return to work under obligations under Bill 41, the communication with WorkSafeBC, and give you a brief intro into some of our online tools that may help you with communication with us. The first one is through our employer portal. The employer portal is located on WorkSafeBC.com, and you log in through the button that's shown above. Once you are able to log in through WorkSafeBC, you will have a choice of tabs: insurance, health and safety, and claims. Through our claims tab, you can choose further down the screen, submit a claims document. That will allow you, once you choose return to work correspondence, to either leave us a text message or to upload a document. So if you're unable to get calls back from your claim owner, you can actually, through that option, text out a message to them requesting a call back with the time, date that you're available, and as much information as you can provide. The same option will also let you upload documents. So if you need to provide a copy of your F7, if you need to provide a copy of any claims information, if you need to provide any suitable job offers that were offered, your communication logs, all of those can be uploaded through this screen and through your employer portal. I want to advise as well that the worker does have the ability to see what is submitted through the portal, So make sure that the language that you're using is one that you would expect someone to read, the worker to read, and not just from us. And that also cautions with, if there's anything that you would want to keep confidential, make sure you speak to us first before submitting anything through that portal. But any of the basic information or request for calls backs can be made through this screen using that particular option. So what if you're a person who doesn't have the portal access? You don't have the email, you don't have the password. Maybe that's something that the HR director has, maybe as a payroll assistant, maybe as a supervisor. You don't have access to that, but you have information that you want to provide to WorkSafeBC. Well, you can do that through our document uploader. You do not need portal access. All you need is the claim number. So going back to WorkSafeBC.com, that review and submit a claim information will allow you on the screen at the bottom to upload documents. So then you can upload any information that you need to WorkSafeBC. This will help to avoid some of the calling back and forth. This will help if you're not feeling like you're being heard, to give you an option of submitting information to us or even request to claim owner directly. Also, if you need to escalate to the claim owner supervisor, they will be able to see in the portal that you have tried to contact them on numerous occasions. So that will help also. If you have any difficulty, like you don't remember your password, you don't know if you actually have access to a portal, or you're trying to use a document uploader and you're just getting confused, we do have a technical support line that is available so that you're able to access all of the online ways to communicate with us, and they will help you out with those. The entire department is just for that purpose, for you as the employer to access information and to be in contact with us. Thank you.
Thank you, Teresa. Sorry, I was having a little technical difficulties there. Lots of great insight. Thank you so much for that. Next, let's hear from Amanda from TeksMed.
Hi, Wayne. So I just want to take a moment to thank everybody for inviting us back to this panel. I think we had some really great questions and conversations come up last year. If you missed that one, my name's Amanda. I work with TeksMed Services. I manage mostly complex claim support, so everything from return to work management to adjudication issues on claims. And we've been invited back here today to talk about some of the things we've learned and experienced since the rollout of this new legislation. So first off, one of the big things, I think the biggest initial thing that triggered with this rollout of this new program was for employers to sit down and assess their current modified duties programs, documentation, all those kind of things that maybe had been on the back burner or hadn't been looked at in a little while. That was a big trigger for everybody to kind of stop and say, hey, we need to revisit this and maybe make sure everything's up to date. So not necessarily a bad thing. I think we've had some time now where everybody's getting into those motions, and if they haven't done that yet, it's underway. One of the things that came up during the last webinar was some of the things that employers could do while reviewing that modified duties program to review and implement best practices. So I'm going to sound super repetitive, just like the last webinar, but again, documentation. It's been a common theme, both from WCB, as well as just facilitating communication with workers and whatnot to make sure that documentation, which includes documentation of not just modified duties offers, but communications with workers is another good one. Your first aid reporting procedures, all those kind of things, and just making sure everybody within the organization is up to speed on how that's going to look. Another thing that has come up is a lot of educating workers. So we focus mostly on the employers, but it's good for employers to realize that to make this process easier, and we can have all these procedures and reporting policies in place, but if the workers haven't been informed of them and they're not being advised of the new duty to cooperate policy, WCB is sending it out with every claim. There's, information bulletins and stuff, but if you haven't had a claim, you might not necessarily encounter those information pieces. So it's a good opportunity for employers to make sure that they're taking a minute tool time talks, those kind of thing, lunch breaks, posters, company-wide communications, and just making sure that their workers are aware not only of their own internal policies and procedures and modified duties programs and contacts, but also of the duty to cooperate. And I think initially there was maybe a bit of trepidation there from employers. They were like, I don't know if I should say anything about this to workers, but WCB has been pretty supportive and clear that it should be communicated to workers. So hopefully I can reassure any employers that aren't aware that, yeah, absolutely, you should have a conversation about the duty to cooperate. A lot of workers are not still aware of what that means on their side and the obligations they have to meet under that. So once you get that open conversation going, sometimes it encourages a little bit more participation in the process and communication back and forth. So another thing that came up was adjudication with documentation. So not so much on the employer side, but one of, I think, the first hiccups we experienced the past 6 months at some point was that a lot of adjudicators at the initial level of WCB were coming back with that they couldn't adjudicate on the duty to cooperate without medical documentation. So that was a bit of a hiccup there. I think there's a little bit of frustration from everyone trying to sort out, what was correct, what wasn't correct. We did get some clarity from WCB that that is not required. So when we're talking about duty to cooperate, offering modified duties, all of those things, you can do those things without medical documentation. Sometimes medical documentation makes it easier. We're all well aware. Healthcare access is a hot issue right now in BC. It's not always available as quickly as we'd like. So when we're dealing with injuries that are maybe not as complex, a shoulder sprain, strain, a hand injury, something like that, you can make a reasonable offer to a worker, and a worker can make a reasonable decision on whether that work may be suitable or appropriate, even if there is no medical documentation. So I would really encourage everybody to start those conversations right away. And it may be that you're able to avoid that lost time, have that worker back in the workplace right away, being productive, keeping that communication open and that connection open with your workplace and yourself. While they wait to get seen by their doctor or find an alternative to maybe their family GP. So that was the first hiccup. Um, the other thing that came up was the duty to maintain employment and the overlap with human rights legislation. And I'm going to really leave that to Chris because he's going to be subject matter expert. But it's definitely been a hot topic. And again, as far as the return to work side of things goes, it's going to come down again to documentation. And a lot of this documentation starts before an injury happens. So some of the frustration we have had is employers who have planned to let workers go for other reasons, maybe shortage of work or whatnot, and that's not coming up until they have an injury, and then they go, "Oh God, like this was a layoff coming up, or we were letting this person go due to disciplinary action." Again, the theme has been, can you prove that? So again, really making sure we're documenting everything, whether it be in relation to the claim, disciplinary, progressive disciplinary, attendance issues, all of those kind of things before the injury happens to really make sure there's a paper trail and documentation there. And maybe it'll never be an issue on the claim. I mean, best case scenario, those kind of things don't affect anything. But that way, if something does happen, it really helps to support your position when you don't have a choice but to let a worker go, or a worker's maybe not cooperating and providing some insight into what's happening there. So those are kind of our biggest things that have came up since this has happened. And I'm interested to get some of the feedback and questions from employers today about what their experience has been.
That's great. Thank you, Amanda. And yeah, I resonate with that. Your responses are great because it really is around proactive communication and documentation. That is going to be, a foundation of any good return to work program and ultimately managing through this. So thanks again for your feedback on that, and looking forward to the question period for our members joining. And finally, let's go over to Chris for your perspective. Morning, Chris.
Good morning. Thanks, Wayne, and thanks everyone for joining us today, and to MSABC for organizing this program. So as was mentioned, I'm a lawyer, a partner at KSW Lawyers. It's a full-service law firm with offices across the Lower Mainland and Fraser Valley. My practice is largely dedicated to advising employers regarding workplace legal issues. So that covers WorkSafeBC issues. It covers things like wrongful dismissal, employment standards, human rights, employment contracts, workplace policies, and oftentimes many of those subjects intersect. And that's happening more and more as this type of legislation comes out, and we deal with issues of dual jurisdiction. I'd say about half of my practice is dedicated to advisory work and preventative work, so planning, dismissal planning, helping employers do accommodation plans, drafting contracts. So we certainly have been dealing with the Bill 41 changes in the context of that advice. And then the other half of my practice is dedicated to more dispute resolution. So either negotiating a disputed claim or defending or bringing litigation either in court or in the appropriate administrative tribunal. So part of that practice, I've done a lot of reviews and appeals in the workers' compensation realm. And I'm probably not in the trenches to the same extent as my two colleagues in terms of the day-to-day issues or advising employers on the day-to-day issues that are coming up with return to work planning and disability management. I'm often getting more involved when there's been an unfavorable decision issued by a board officer, whether that's with respect to return to work or vocational rehabilitation. And I'm often representing employers with respect to doing a review at the review division or an appeal at the workers' compensation appeal tribunal. And my initial thought when I reviewed the Bill 41 legislation is like, man, we're going to have a lot of disputes and appeals, and I'm going to be trying to overturn administrative penalties being issued against employers who aren't complying with these duties, or maybe there's some members of our team that represent workers as well, so they're going to be busy trying to appeal decisions of benefits being suspended and all that. And based on the first 9 months or so, that hasn't really been the case. That may change because I think we're still in the very early stages of these duties, just coming into effect this year. And it could take, months or even years for a case to kind of work its way through the various appeals. And maybe Teresa could speak to this a bit more, but my sense is that WorkSafe is approaching this year as being more of a time of education for employers, focus on kind of support, voluntary compliance, rather than enforcement and adjudication going to those formal decisions and penalties. So I think that's a good thing to let everyone get accommodated and understanding, because these are big changes, these are big impacts for both workers and employers. And for that reason, we haven't really seen a lot of review decisions from either the review division or the appeal tribunal. That being said, there's definitely been a lot of guidance issued by WorkSafeBC. So if you haven't had a chance to review the policies that have been provided with respect to the duty to cooperate and maintain employment, I would encourage everyone to review that. It's policy item C5 35.10. And then there's also a practice directive, C5-6, which is a 21-page directive, which kind of is repetitive of the policies, but gives a little bit even more detailed guidance than the policies do. And it's important to remember that the policies are binding, but the practice directives are not. So some of the questions I've been seeing from some of my clients is how soon can I get in touch with my worker who's been injured in a work-related injury? And we now have this wonderful duty to cooperate, which is reciprocal. It's a mechanism to allow the employer to actually start communicating with an employee who's injured at work. It doesn't allow what we might have seen in the past, where the worker would just kind of disappear and wouldn't communicate with us, and we wouldn't hear from them. We'd only hear through the case manager or through their doctor. So the policy speaks to that and says that the communication has to occur as soon as practicable. And, that's kind of a legal term, but what the policy kind of breaks it down is as soon as is reasonably capable of being done. So that's kind of some good guidance to know that you can really start working with your workers immediately after they've had an injury, subject to, if it's a very serious injury or there's other reasons why they might not be able to communicate with you, which is one of the exceptions to the duty to cooperate. And I think it's great because the duty actually has some teeth. If the worker doesn't cooperate, that could result in the suspension or reduction of benefits. And, that could be on the board's initiative, or the employer actually has a means to file a complaint, and the board has to give a ruling on that within 60 days. I've not personally seen any of these rulings, whether that's an employer initiating a complaint as to whether the worker's cooperating, or whether the board is just on its own initiative looking into that. Nor have I seen any administrative penalties issued against employers with respect to breaching the duty to cooperate. So I'd be very curious to know if any of you folks have tried out that process and have got a decision, or if you've seen any penalties. Another big question I get is what's suitable work. There's, we have this duty to, work together and come up with work that's actually suitable. There's again a ton of guidance on what constitutes suitable work in the policies and the practice directives. It needs to be safe, productive, not just token or symbolic. It has to be within the worker's functional restrictions and within their qualifications. So there's lots of helpful guidance there. And another big one I get, and one that I'm sure Amanda's dealing with all the time, is whether a worker's refusal of the presented suitable work that comes out of this conversation in the duty to cooperate, whether the worker's refusal of the proposal is reasonable. So how does the board determine what's reasonable or not? And again, there's a whole bunch of factors that are set out in the policies there. Some interesting ones I found were the board will actually consider something like transportation. So if the suitable work is at a different location that changes the worker's commute, or something like that, that may be a reason for them to refuse it. A dependent care is another factor that the board will consider. So if the suitable work alters the pre-injury childcare arrangements that the worker had, that could also be a reason for the worker to reasonably refuse that suitable offer. Another thing that I've seen in the policies, but also in the few review division decisions that have come out evaluating the suitability of offers from employers. Generally speaking, if the worker relies on their family doctor's opinion to refuse the suitable work offer, the board's gonna accept that. Now, the board has a right to have its own medical advisor look at it. The board's internal advisor can talk to the worker's GP. But based on the 15 or so reviews that I looked at, generally speaking, if the GP, says this worker can't work at all, or this, this modified offer is not appropriate, the board's going to go with that, and the review division's going to affirm those decisions. The one successful review I saw was where the worker had not actually presented the details of the modified offer to the physician. And so the physician had just done kind of a blanket, cannot work type of thing. And it came out in the review that, there was a reasonable modified offer there. It hadn't been presented to the physician. Therefore, the review officer, didn't give any weight to the physician's opinion. So again, it's hard to make those modified offers stick, but again, documentation is key on that, and getting as much information out there as possible. And then if the worker doesn't properly present that to their medical professional, then you may have a better chance on review if you decide to do that. I won't go too much longer here, because there's quite a bit. But on the duty to maintain employment, some questions I get are, does it apply to me? Am I one of the employers that it applies to, and also does it apply to this worker in particular? There's some nuances around that again you can see in the policies. So it doesn't apply if you employ fewer than 20 people, and the wording used is regularly employ. So what does that mean? There's some guidance in the policy on that, but generally the board's looking at how many employees you reported taxable earnings for to the CRA in that year. So that's kind of a baseline to look at. I haven't seen any decisions yet interpreting that or looking at it in any other scenarios, but again, I'm sure there's been lots of guidance given by WorkSafe to employers on that. And then the other one is the worker has to be continuously employed for 12 months for the duty to maintain protection to apply to them. And again, there's some guidance on that in the policy. It doesn't have to be 12 months of active work. So if the worker has been on vacation, if they've been sick, they've been laid off, they're still going to be considered as continuously employed over the 12-month period. And there's also some exceptions for seasonal workers with a pattern of recurring employment. So again, it's meant to be more inclusive than exclusive in terms of bringing more workers into having this protection. So yeah, those are just a few of the major questions I'm getting, but I'm looking forward to speaking with you guys and going through your questions.
That's great. That's a lot of information, and I know this webinar is going to be full of it. So thanks again for your insight, Chris, from a legal perspective. So thank all of our panelists today for getting us caught up and setting the stage for the questions. And so maybe if I can invite all the panelists on now to join me. And then I think I'd like to start with two of the questions to the three of you. And I'll start off with this one. What has been one of the biggest misunderstandings about this legislation that you've seen so far? And really, I'll leave it open for any of you to start as you wish.
I think from what we've heard from our clients, the biggest misunderstanding was there was a lot of fear and trepidation about financial penalties coming down right away, that there wasn't going to be a whole lot of communication back and forth between clients and the board. And we actually haven't experienced that. So I think Chris kind of touched on that. I haven't seen any financial penalties to an employer yet, at least as far as our clients go. I have seen compliance officers reach out and investigate matters. There's been some back and forth both at board level and with Voc Rehab around the duty to maintain employment. But I think WCB appears right now to still be focusing on that educational piece. So it's, like I said, just a lot of information sharing because all of these cases are so specific.
Yeah.
Also, I could add on to that. That I think one of the misconceptions we see is that when employers have something that's working for them, they're not necessarily thinking of compliance. So they're not necessarily reaching out to people at the first moment practicable. They're not, there is no exception for mental health under the return to work obligations for Bill 41. And sometimes they're still not necessarily reaching out to people who may have a mental health or psychological injury. And it's not an intentional not trying to cooperate with the legislation, but it's that their injury management program has been effective for them. But it's not necessarily always compliant with what is written now in the new legislation.
And maybe a bit further on that, Teresa, I know that a number of members have talked to me a little bit about mental health and, being able to support workers, but feeling not equipped to have that conversation with employees and feeling that maybe they are creating additional psychological injury by probing questions or, perhaps putting them in a position that makes them feel that they're getting pressure from their employer. So could you maybe also all three of you, could you speak to that? Because this is a challenge where a lot of employers don't feel that they are equipped with the right tools or the right ability to, perhaps have those conversations with workers.
Absolutely, Wayne. You're definitely hitting the nail on the head, and so are your employers. And we hear them, and we are creating more and more resources to help people to speak with their workers who have mental health or psychological trauma. We're creating these resources to help. And also my department that I work in, Return to Work Consultation Education Services, is also there to be a consultation for you, so that if you do have questions on how do I reach out to this person, how do I make this work, it's there for you. People with any type of injury, if they stay connected to work, if they are able to continue with work, it helps them with their recovery time. Studies show that they recover a lot faster. So sometimes it's simply just broaching the conversation. It can be uncomfortable for both parties. Certainly people who are dealing with mental health trauma understand the stigma that they're facing, and also the employers, just in care and concern, not necessarily knowing how to approach it. Sometimes it's just best to pick up the phone and just say hello. Just say hi. You don't always have to just jump into a conversation about, so when you're coming back. It can just be, hi, how are you? How are you doing? If there's anything you want to share medically, if there's any part of the job that you think you can do, that is there, just having a discussion. And then if it seems and it feels like it's not a successful conversation, then you can reach out to WorkSafeBC and make sure you document, in your communication logs that you reached out, but just felt like now maybe is not the time to have this particular conversation due to, and explaining why not. But it's best for both people to reach out. For a lot of people, their job is their identity. It's part of what makes them who they are. So the option to stay connected and return to work is something that a lot of people look forward to. So it's definitely worth the try, even on just a regular standpoint, not just legislatively.
Yeah, and before I go to Chris and Amanda, because I know they can add some perspective on this, it is a growing thing. And I think, knowing that employers have, WorkSafe and other groups to reach out to. I know even with ourselves here at the Alliance, we've got our own mental health, practitioner to help people around the conversation, right? Again, you're not the therapist. You're simply just engaging in a conversation so that they could still feel safe. But I agree with you, Teresa. It is a big part of their identity being at work. And so having that disconnect can be quite impactful as well. So maybe I'll go back to Chris and Amanda. Any other thoughts on around the mental health side of things?
Yeah, I mean, I think it can maybe be counterintuitive or against kind of what our first thought is with respect to immediately contacting the worker that is dealing with a mental health issue. And this duty to cooperate, it's kind of unique with respect to, it applies to workplace injuries, right? And so if someone was off on a mental health issue unrelated to the workplace, employers would not have the same ability to be able to contact the worker and kind of require them to communicate with you and all that kind of stuff. That's just not done for injuries that aren't work related. And ultimately the accommodation process, even in the human rights context, it has to be a team effort, right? And so if a worker wants to be accommodated, they need to be part of the conversation, and they need to be volunteering information about how they're doing everything. But I think the employer, it has the most detailed and substantive set of rights in terms of being able to kind of compel the worker to be involved in the process at a very early stage, because it's a workplace injury, and all employers have skin in that game. I'd be curious to know, either from the other panelists or members here, if anyone's come up against resistance on that, on the basis of the exception that it's going to imperil the worker's recovery. I suspected when I saw that in the legislation that workers with a mental health injury would be pushing back and saying, well, any communication now is going to set me back. I need complete interruption from the workplace for 3 months or something, and here's my doctor's note. Curious if anyone's come across that.
Yeah.
Yeah.
Oh, sorry. You want to go ahead, Teresa?
No, please.
Yeah, I think we've had that issue come up, and so far, it really depends on the circumstances. So the two cases I'm thinking of, were physical injuries where the worker, provided a note and just said like, no, I can't have any contact with work. And it didn't really hold water with WCB. But when it's a mental health claim, again, it's really going to depend on those circumstances. We have another claim that is related to, an issue and an altercation in the workplace. And in that case, it's been supported insofar as contact between the two individuals involved. So there's, I think, a lot of playroom being left open to wiggle in there, but very much like both of you touched on, we encourage all of our clients and us ourselves. We reach out to workers immediately following an injury report, and that whole mental health landscape, I think, is just emerging and changing so quick. But I think a lot of it comes down to feeling out the situation. When employers are contacting workers directly, you may not be able to request that medical detail or what exactly is going on, and the worker very well may have personal things going on. But I think it's important to reach out and say, "Hi, how are you? We're here if you want to talk. If there's something we can do to ease that transition back to work or support you in the workplace." Another big thing has been that shift with mental health claims. When we talk about a physical injury, we're very focused on suitable work, right? Like it's very easy to say, okay, this duty requires no use of your right arm. So there's a shift there when you're dealing with mental health where you're not dealing with physical limitations. So you really have to slow down, involve the worker if you can, to kind of get a feel for what the situation is, because it may be something like reducing the workload. It may be, level of exposure to the public. If you've got a very stressful, hectic kind of position, it may be taking a step back from there. There's a lot of different scenarios there, and it's hard to speak in generals because it is very specific to that person's situation, that person's injury or claim or disorder, and the work environment. But I would really encourage employers to reach out to the worker. And I mean, sometimes you'd be surprised at how much information they just want to hear from somebody and know that they're not going to be ostracized. So when you connect with them, it's like, hey, this has been going on, or I need this, or and you start to identify some of those barriers and some of the issues that are preventing that engagement with the workplace. And when you can slowly kind of address those and let them know you're there to work with them, it seems to go much smoother going forward.
Yeah, I think those are great insights. I think the big part, of course, is then I think from an employer standpoint is getting some of those soft skills so that you can again, be prepared to, engage your employees in the event of a psychological trauma and just being, open-minded and how you approach it. Listening is a real big thing. When you ask a question, how are you doing? Stop and listen and let the employee have a chance to communicate with you. Really great things. Teresa, I think you had one more comment here, maybe?
Yeah, I was just gonna mention, like, just kind of piggybacking off of what Chris and Amanda said, that, just like with trauma, you have some injuries that are very, maybe just a sprain of a finger on one hand, so it's more isolated. You can quickly look at suitable work, and then you have more catastrophic physical injuries that sometimes take time and a lot of conversation. It's the same thing with mental health, just depending on what we're seeing, what was the source of it, what happened, and the different levels. But currently I've been working with a project on pending claims that haven't become claims, and have seen the doctor's notes where it's like 3 months off, just 3 months off. And then we have return to work specialists who are sometimes contacting the worker. And sometimes, not all the time, sometimes they're like, I actually would consider that, if we actually spell out what a return to work looks like. Sometimes it's fear on both ends. What does it look like for me to go back to work? Are they just going to throw me back in my job? Do I get any say? Do I get to, what does that look like? So sometimes in our conversation, just making sure that, one, we're making it clear that we are listening to what the person is saying they can and can't do. And two, that if there are options to work with that you make it clear that you're going to try to work with them as much as possible. Sometimes if it's coming from us, they feel like we're definitely going to do it. We're going to see it, the medical, we're going to definitely try to make it happen. But we want that to shift to the employer where they're having those conversations and they're able to make it happen. But yeah, it's not a quick and simple answer, but definitely more conversations, as Amanda was saying earlier, around what does it look like to return to work.
Yes, yeah. And I think I could probably spend another whole webinar just on mental health, and maybe that's a new topic coming forward, because honestly, there's a lot of things around creating resiliency in the workplace. EQ versus IQ. This is a course that we offer here at the Alliance. It's just helping employers, helping workers, just building on some of these skills, because we know that there's a definite need for that. So I'm going to park this part of the conversation because I know we've got a lot of questions in front of us. So maybe if I could just bounce along here to the three panelists. What are the biggest, or what, sorry, is the biggest challenge that has arisen for employers as they try to stay in compliance with new legislation? And what about for workers?
I think for employers in our experience, I think the biggest one was, again, building up those internal documentations and procedures. I think there was a lot of gaps maybe that came to light. Maybe it was supervisors weren't fully informed of even an employer's obligation, so they maybe weren't making that offer of modified work right away, or weren't as on board in identifying suitable work. So I think that was a big piece for the employers, was just making sure they were educated and set up within the organization itself. And then for workers, the flip side of that, a lot of them weren't aware of the duty to cooperate. Sometimes we still encounter workers who don't believe that they ever have to work outside of the scope of the work that they were hired for. So that's been a big learning curve, that modified duties are not always preferred activities. They can be, temporary work in a completely different department or something. So just a lot of educational bits and pieces, I think, is what we're seeing.
I could also agree with that with Amanda. What we're seeing is the reason that I shared the slides this morning was because that how do we communicate? How do we document? How do we provide WorkSafe with our documentation has been one of the biggest pieces. And again, a lot of times things are done right or effectively. They're done correctly. They're done in a way that's compliant, but there hasn't been that communication piece on the file, on the claim, so that people can see it. So then we're having to call back and call back and call back, and then there's a miscommunication. So if the information is uploaded right away, it really helps us to be able to see that everything's done and to move the claim through a lot quicker. For the worker, I can't remember who said it earlier, but sometimes they don't really think about the return to work obligations until there's an injury. And you could go years without ever being injured. So you don't really think about it. You're not in it like we're in it. So you're not really as aware as maybe as you want to be. So things like sometimes the workplace culture, I'm not calling them, I'm gonna wait for them to call me, with the duty to cooperate, it's on both ends. You're both supposed to be communicating with each other. And also refusing work. You can't unreasonably refuse something that's suitable. That's why we want that conversation, because you should be having the conversations about what is meaningful, suitable work for you. So that's definitely what we see from the workers.
Great. I'm going to go a little off script here because we've got a tremendous amount of questions coming in. So I'm going to pause on some of our scripted questions, and I'm going to jump in because I would really like to, be able to answer a number of the folks here today, their questions. So maybe I'll start with this one. This question is about return to work after an injury. The situation is that there is an offer for suitable, reasonable, light work duties from the employer to the worker, but there has been a denial from the worker or worker's physician to return to work. In addition to this, there are constant extensions on the functional abilities form to stay home. Is there any process that can help employers with more transparency? So really getting them, to an agreement, I guess. I'll open that up to all of you.
Definitely. Every claim that is filed, whether you are accepted or not at WorkSafeBC, can go to a physio. Sometimes having a physio look at that person, look at the job, that the suitable work that's being offered, and actually applying their functional tests can be clarifying for both the worker feeling more confident about going to work and the employer and the type of work that they are giving. Now, if you are offering suitable work and it is work that that person could do, in your opinion, you are definitely welcome to upload the suitable work offer, the conversation you had with the worker in denying it, and the medical information, and ask that claim owner to make a decision that, because you've done everything that's on your end, And sometimes it is about dotting the i's and crossing the t's, doing as much as you can on your end and making us aware of it, and then requesting that that claim owner intervenes. Because if the information is there, we're not blindly accepting what a doctor gives, but we definitely aren't ignoring it either, because they're doctors for a reason. So if they're giving a blanket 3-month off, we're going to be questioning that. If they're giving a blanket no without any explanation, reasoning, or something that we can follow, we may have a question for that. So make sure you're doing as much as you can on your end, so that then we can ask the clarifying questions and get to the bottom of it faster.
That's a great answer. Thank you. The pause will say is good. So I will move to a question directly to Amanda. How can an employer assess or assign modified work duties without a medical note or an assessment?
Yeah, I love this question. So, one of the things, and this does kind of touch on issues that we've talked about already. I just want to mention it real quick so it doesn't get overlooked. Part of that duty to cooperate is inviting a worker's input. So let's not overlook that, because if you're questioning that suitable modified work and the worker saying, no, I can't do that, there is now within policy, you can say to the worker, okay, what would be suitable to you, or what is something you think you can do? So we like to include that in those offers where we can show that we've made the opportunity available to an injured worker or an injured person and invited their input into different aspects of modified work. So you have a situation where a worker has been injured, maybe they can't see their doctor right away, they can't get into the clinic, and employers often say, well, how can I offer them modified duties? So it's based on a reasonable offer. So that means that as an employer, you need to assess the situation, and it's not going to work in cases that are very complex, where it's a serious injury, where um, maybe there's a mental health component or something like that going on. But in cases, the straightforward injuries that we're dealing with and seeing most often day to day, it's something like an ankle or your back or a shoulder. So for a reasonable person, you can look around your workplace and start identifying tasks that will not cause harm or further injury to that injury. And that's kind of the key component there, is you need to identify something. So if it's a shoulder injury, maybe administrative duties where they're just writing with their right hand because their left arm's injured. If they've injured their ankle or their knee, maybe you can offer them something that's seated. Maybe it's not even a different duty. Maybe you can bring a chair to their workspace and they can sit down to perform that task. So those are the kind of things we look at, and those are the kinds of things you can offer. There really is no definition on what you can offer. You can offer anything, but it has to be not demeaning, not token. It has to reasonably appear as though it would accommodate the injury or what the common sense limitations or restrictions associated with that injury are. And you can present that to the worker. And to circle back on what happens if the doctor says no and the worker just refuses it, the other key component there too is that workers do, when they seek medical, have to advise their doctor of the available modified work. And we have had successful decisions come back there. I don't know if that's one Chris saw in the review division, where workers have just said, no, my doctor said no. And it turns out the doctor wasn't informed of the modified work. So when you're making those offers, you can make a reasonable offer. And as long as that's documented and on file, like Teresa said with the board, you can ask an adjudicator, even if it is after the fact, to go back and adjudicate on that issue. And if that offer was reasonable, and they'll be able to look at the circumstances of that case and generally make a determination that the offer was reasonable and should have been accepted, based on common sense. A reasonable person would determine they could do this without harm. Or maybe in a case where it's a more serious injury or it's more complex, they may, hold off on that to get further medical clarification. But that certainly shouldn't be the case in the more simple or straightforward injuries.
Great. No, that was a really good, thorough answer. Thank you, Amanda. Going over to Chris. We've got a legal question here about confidentiality. If the act of one person, an employee, impacts another person, another person, where am I going here? I apologize. The employer, how does confidentiality work here? Everything from the employee side is concealed from the employer, while they must still cover the claim's cost. So That's a good one.
I may need a little more
Yeah, I'm
context on that.
just seeing there's some edits being done here. So let's take it from the top again. This is around if the act of one person, an employee, impacts another person, the employer, how does confidentiality work here? Everything from the employee side is concealed from the employer, while the employer must cover all of the claims costs. It's a bit of a
Yeah, I don't know quite what the question is there.
yeah.
I think in terms of employers having access to the information that's associated with the claim, you know, if there's a review, then the employer has, you know, full access to the claim file, so they can, you
Yeah.
know, they can see the details of, you know, whatever complaint was made. Or but I think I'd need a little more context to properly
Yeah,
answer that.
we'll frame this one up again. When I read it the first time, I thought I had all of the information I needed, but let's maybe run to a different question here regarding return to work and duty to accommodate. What else can employers do when we have maintained communication with the employee, provided work offers, documented in the portal, requested numerous callbacks regarding the claim, but yet still no response from WorkSafe to either the employee or the employer? What are the next steps that employers can take in these situations? So we've got someone obviously experiencing this. So this is something I commonly hear, right? When they can't get an answer from WorkSafe. And so what can employers do here?
I can say that's very frustrating and I understand. We are definitely working on our responsiveness and making sure that we have enough employees to deal with all of the issues that our employers are currently experiencing. For now, what I would say is it sounds like you are dotting the i's and crossing the t's to whoever asked that question. You are not only offering the work and having the conversations, but you're also uploading them to the portal. So if you have in a text asked for a call back by the claim owner and you've given them a specific time to call you back and that's still not happening, now's the time to escalate to a supervisor. Because when they go in, they will see everything that you've put in there. They will see that you have offered, they will see that you have attempted to call, they will see that you have on numerous attempts, attempted to call and attempted to connect. So when you escalate it to a supervisor, they will be able to help you faster, and everything's there. So it doesn't have to be a story between you and the claim owner, but they will be able to see everything that you put in there and help to make sure that you get the attention that you need. You can just call right through our customer service for claims and ask the representative to connect you to the supervisor of that person that you're trying to contact.
If you don't mind, Wayne, I'll share two quick tips
Yep.
and tricks there. One issue is when people are trying to get a hold of a claim owner and maybe those calls aren't getting logged. We've experienced that. So I always encourage people to call the call center and log those callback requests, so you know that they're going to appear on file when a supervisor circles back to see what's going on. And the second thing we've had a lot of success with is the issue resolution office. So problems that are filed there, we're getting same day callbacks, escalations to supervisors and managers. So some really quick resolution from that avenue.
That's been my experience as well, is getting a call back the same day when we contact that office.
Yeah, it's been great.
Yeah. The other thing, if you feel you're kind of at your wit's end with WorkSafe, and you can't wait for a resolution office or a supervisor, you know, if you're confident in the fact that you have a reasonable modified return to work plan for the worker, you know, you can present that to the worker and say, you know, we expect you to be back on this day at this time and under these conditions, right? And if they fail to do that, you can take the position that they've abandoned their job, or they're not participating in the accommodation process. You're taking some risk in doing that, obviously, if you sever the employment relationship, and WorkSafe ultimately determines it wasn't a suitable offer. You could be in trouble there. You could have you know, wrongful dismissal on your hands because you've terminated someone. But you know, if you really want to make something happen one way or the other, you can give that kind of final ultimatum to the worker if you feel very confident that what you're offering is reasonable and within their ability.
Thanks, Chris. Yeah, I think that's great. advice on that. Another question, maybe in regards to an employee's obligation to share the functional abilities form. Is the employee required to submit the form immediately upon receiving it from their healthcare provider? There have been instances where employees delayed sharing this form, which has led to lost time, and this delay was accepted by WorkSafeBC. Is there a way to prevent this delay? And I do hear this as well as what happens in these delays, and what happens in this, and how do we prevent it?
Well, from my end, yeah, it's their medical information. So if they're not sharing it, it can become problematic in that you're not getting the information right away. That is why we do not need medical information in order to offer suitable work. So the conversation is what you want to have. You want to ask them what they can do, what they can't do. What about your job can you do and not do? Is there a job here that you see that you can do? And you want to offer what you feel is suitable, reasonable work, regardless of whether you had the assessment or not. And if they turn down because they cannot unreasonably refuse suitable work, if they turn it down because they feel they are physically not able to do it because of the result of the functional abilities form, they're going to have to prove. So they're going to have to submit something from somebody saying that that job is not reasonable and it is not suitable for them. So the best thing that you can do is go ahead and make that offer. Go ahead and have a conversation, log the conversation. Based on our conversation, we feel that this is suitable work. This is what we're offering. If they will converse with you, but yet you know the type of injury, a lot of employers, they have the same types of injury. Everybody kind of injures this part of their body or that part of their body. So you know what type of work you typically offer. So if you do have some type of work that usually works for people or that is extremely light duty, offer that to the person, because now you're shifting that over to them to either communicate with you to tell you why not, or you're going to, the claim owner is going to have to push to get you more information because you've done everything you can on your end.
Great. Thanks, Teresa. Chris, I got a question here for you, and this was something we'd lined up already. How can employers handle accommodation requests from employees who may have health concerns or other reasons for needing special arrangements under this new legislation?
Yeah, I mean, this is it's a really interesting question, and the one thing to make clear is, the duty to accommodate has been around for a long time, right? It's been around under human rights legislation, and so there's already a really well-established body of law that's been built up through the Human Rights Tribunal, kind of addressing what is the duty to accommodate, what are the potential defenses, what is an undue hardship, all of that kind of stuff has kind of, been well established through the Human Rights Tribunal. And so there was a lot of kind of interest and potentially some concern when this legislation was coming out, because now we're going to have WorkSafe dealing with the question of duty to accommodate, whereas normally it would just be the Human Rights Tribunal. So you have kind of two different bodies looking at the same question, but there's subtle nuances between the two, because WorkSafe obviously is only dealing with work-related injuries, and whereas the Human Rights Tribunal, it doesn't matter what caused the injury. They're looking at it from I guess, a more broad perspective. And so there was some concerns that maybe the way WorkSafe looks at it is going to be different, and so you're going to have, one duty to accommodate for the WorkSafe, and then you have another duty to accommodate for human rights, and how is that going to work? What if WorkSafe makes a decision as to something being an undue hardship, and then does that mean you can rely on that, or can human rights look at that down the road at another time and come to a different conclusion? So there's lots of kind of interesting questions that arise from the fact that now there's two duties to accommodate. But from everything I've seen and from what I've read in terms of the policy papers that resulted in these changes, I think there's going to be a big effort to have the approach be the same or as similar as possible between WorkSafe and human rights. And I think that's reflected in the policy and the practice directive in terms of what are the relevant factors in determining if the employer can accommodate someone. What are the factors in terms of assessing whether something is an undue hardship. So, the board is looking at things like, are there safety risks by bringing someone back into a certain position, either to the worker or to the rest of the workers? How big is the employer? What are the how flexible and interchangeable are positions? How easy is it to kind of shift someone over or modify someone's duties to bring the worker back and accommodate them into a slightly modified position? Is there a collective bargaining agreement? Are there issues with displacing other employees by doing the accommodation? All that stuff, I think, is going to be properly considered by the board when assessing if an employer is accommodating properly. And again, we haven't really seen any authoritative decisions on this piece yet, but I'm basically advising employers the same way I always have with respect to the duty to accommodate. It doesn't matter that it's a workplace injury. We're still doing the assessment of, okay, what do we have here? How many different positions are there? What do we have in terms of medical information? What has the worker told us? What has the doctor told us? What's it going to take to reasonably accommodate this person? Is it too much that it's an undue hardship? It's the same analysis really for both tests.
That's fairly complex, but I think that's a really great perspective for our folks joining us, because again, it's new to some, and I think getting good advice through this process is really important. Maybe I could piggyback on that. Does duty to maintain employment pertain to claims in excessive period of time, say 3 years?
So my understanding is if the worker's been off for 2 years without coming back in any capacity, then the duty to maintain ends. And so it almost kind of lines up with this other common law concept of frustration of employment, where if someone is off, injured, totally disabled, and unable to work for a lengthy period of time, then the employment contract becomes frustrated by operation of law, and the relationship ends without any obligation. So it kind of mirrors that concept. But my understanding is after 2 years, the duty to maintain ends. Now, I think that is kind of dangerous because it ends for the purposes of WorkSafe. And this is one of those examples where it's actually different with human rights, because human rights, there is no like time limit on your obligations to accommodate someone. So, if someone's been off for 2.5 years, you may not have to bring them back for WorkSafe purposes. But if there's any reasonable prospect of them being able to come back in an accommodated position, even if they've been off for 2.5 or 3 years and you terminate them, there could be a human rights claim there. Yeah. So, again, what's applicable to WorkSafe may not be exactly the same as human rights, and that's actually a perfect example of it.
Yeah, so in this case, I would definitely, seek some employment legal advice before proceeding, because I think again, there are two different bodies here that you have to consider.
Yeah.
Excellent, thank you. Maybe I can go to a question here from our viewers today to Teresa. Can you share about training and consultative services? Like, nurse advisors have come to members' work site and provided return to work training to one of the attendees and supervisors, and their program was amazing. So maybe if you've got a little bit of a share on that, that'd be great, Teresa.
Absolutely. Thank you for the question. My particular department, return to work consultation and education, is just that we provide education to employers, whether it is on best practices, creating better injury management programs, whether it's supervisor training, or if it's additional training on the return to work obligations under Bill 41, we provide that information on how to use the portal. Depending on what your needs are, we will work with employers also in consultations where if you find that you are paying a lot to WorkSafeBC, we will help you to make sure that you're following those best practices and reduce your claims costs over time. We've been very effective when we're working with an employer and helping to reduce their claims costs. We do have a group of return to work specialists, some nurses, some kinesiologists who do go out and will go face to face with the employer and give definitely learning opportunities there, also to do site visits to see, make sure they understand your operation and make sure it's very tailored to your place of employment. It's not just general information. We can get very specific as well. And we can also do claim file reviews where we're looking at your claims and we're seeing, you know, where some of the breakdown in the communication is with WorkSafeBC forms that we may be looking for that you may not be getting in. Are you protesting everything that comes in or only the good stuff? You know, we can talk about all the data and that we're seeing on the claims and also in our employer report card to help you to reduce your claims costs and make it more effective for you as well.
Great. And I know that Amanda, your team as well, does a lot of work in this area.
Yeah, so part of our clients coming on board with us as we help reassess or assess or set up a disability management program internally. So a lot of employers have something kind of loosely put together, but part of that process is us assisting them with things like identifying modified duties, making sure that they have got proper modified duties offers, that those offers are being made right away, documented, things like reviewing claims costs and assisting with adjudication issues. So there's really like a whole bunch of different factors when it comes down to it. The first step being is that hopefully you're not getting to that place where you're having the high claims costs. So the focus is trying to make sure that modified work is available. The offers and communication bits and pieces are there so that, you know, it's the exception to the rule, not the rule, that we're having issues arise on claims.
Yeah, that's fantastic. And again, I think the idea of this webinar is to show that there is a lot of support for members out there. WorkSafe has a great support network. Amanda and her team at TeksMed have it. Here at the Alliance, we have a team where we're trying to actually prevent the accidents before they even happen in the injuries, right? And of course, Chris providing that legal guidance along the way. So thank you again for all of your answers to help support our members online today. Different question here. What if a worker has injured themselves during modified duties? That's always a great one. What can employers do? One employer shared that they've had employees who tries to injure themselves during. Well, again, hopefully that's not the case. That's the exception, not the rule. But what does an employer do in this case?
Yeah, I think for our clients, you know, a modified, you want to make the initial modified duties offer. You want to get that out there, get the ball rolling, get the communication going. But a good point is that the ball doesn't stop there. So as this person is recovering, we need to make sure the supervisor's involved, you know, the other stakeholders in the situation are involved, are connecting with the injured worker, are supervising them, that there's review of the work they're doing, and that modified work plan is being updated and reflects either the current medical on the file, or maybe some issues that are arising at work. So, you know, you can put together a fabulous plan and put it in place, and maybe it's just not working. You know, unfortunately, there are some bad players. So you may have a worker that's not adhering to that plan, and you need to go back to it and revise it. Some things we found successful in those situations are maybe looking at changing hours. Sometimes those cases are, you know, on a night shift or something. There's not a lot of supervision, not a lot of structure going on. Seeing if a worker's open to attending during the day. Chris did touch on that once we start changing hours and stuff, that can become an issue. But you know, sometimes workers are looking for that support in that direction. So they'll say, yeah, you know what, I'll come in during the day while I'm recovering, and then a supervisor's there if issues come up and something needs to be adjusted a little bit. So I think it's just maintaining that communication once you start it, and that involves making sure the worker's providing you with updated medical. You know, if it's a very limiting injury or there's limited modified work, you may have to pause a modified work program. It's not ideal, to get some clarification, but there's lots of different avenues. It really just depends on the specifics of the situation.
Yeah, I think you know, one risk you have of moving too fast or being too aggressive with the return to work plan is, yeah, the worker could re-injure themselves. And that would be, you know, compensable, and we'd be back to the drawing board. And they may even be in a worse condition now than the original injury. So yeah, you know, it's a balancing, right? In
Mhm.
terms of, you want to get them back as quick as possible. But also you need to be mindful of, you know, is this actually going to help them, or is there a risk they're going to hurt themselves, and, you know, the claim's going to go on even longer than originally it would have.
Yeah, and when we're looking at making those modified work offers without medical or kind of initially, our advice to employers is always play on the safe side for right now. So for
100%.
right now, maybe you just offer sedentary administrative duties. We wait until there's more medical or more limitations available or the claim owner's available. That way, you know, you're not on that gray area. Everybody knows it's safe and there's a little bit of time to kind of go back and get more clarification.
Yeah. And Amanda, what do you advise your clients in terms of um, making sure it's not that token work, you know, come in and watch some
Yeah, it's got
YouTube
to be
videos or something?
meaningful
Yeah.
to the business is usually my rule is there has to be some kind of operational benefit to this person doing this. So, you know, sometimes workers don't want to work in another department. We've experienced that too, where a worker says, I'm not working in the office. That's not what I do. I'm a labor guy. Um, it doesn't have to be preferred work, but we do caution employers it does have to be meaningful work. So there has to be some demonstrable benefit to them doing it. And when you look at it that way, another issue that comes up too is like with training and stuff, we always encourage them to do things that are trackable. So you can't say, oh yeah, I sent the guy home to do some studying, you know, but it's a lot different if it's an online course where they log in and there's grading and scoring and attendance records and stuff like that. So that always helps to kind of clarify the situation so that hopefully that confusion's not coming up down the road.
So counting paper clips is not one of those things. All
Nope.
right. Clear as a bell. Chris, I think we could probably do a webinar just on employment law and educating, you know, employers a little bit around some of these nuances, because it kind of gets a little sticky here on, you know, again, the actions that you have to govern your own business, but also not going and obviously impeding, you know, human rights. So, you know, maybe some follow-ups to this as well. I want to stick on this conversation if I could. So another question here is, in some cases, initially the adjudicator determines that modified duties offered are not suitable or safe for the worker at the early stage of the claim, but later the case manager reassesses and deems that the same modified duties are now suitable, considering the worker's limitations or restrictions. This has resulted, did I answer something or answer this before? It feels a little bit similar, but this has resulted obviously in lost time, and now the worker is reluctant to return to work. What would be the guidance you would provide in this? It sounds a bit familiar, but maybe we can just provide a little bit of guidance.
Yeah, definitely. There, it depends, you know, that's the first way I usually start a lot of the questions, because if you don't have a particular claim in front of you, it's really hard to flip through and see exactly the train of thought that's going on. Some people do improve, and in their physical aspects, sometimes there is medical information that may be suggesting that they are limited in what they're able to do. And then later there's more medical information on file that maybe gives more information so the claim owner can help them go back to work. As Amanda was alluding to earlier, is that we don't want people, and Chris as well, that we don't want people just to go back to work quickly, we want them to go back safely. So sometimes there is more information that kind of helps along the decision. If you feel like that something has happened and that there was a situation that maybe left the person off longer, and in that regard, depending on how the worker's receiving it, if they now don't want to come back to work, I don't know how much time has elapsed, you know, you can get assistance from the claim owner in speaking to the person and helping them to get back to work. We have planners and specialists at WorkSafe that help specifically with drafting gradual return to work plans. So maybe getting, you know, asking the claim owner to have one of them involved to help with that process is something that definitely can be done. And then also, you know, if you know, you really feel like something has not been done correctly in the file, you can always ask for a decision and appeal it. So if they are saying that this job is not suitable, ask them to make a decision. Tell them you'd like a decision letter on the work not being suitable, so that you can, if you feel that very confidently that it is something that they could do.
Great. Thank you, Teresa. I'm just being cognitive. We've got about 9 minutes, and I'm going to try to answer as many more or get answers for as many more questions we have here. So if we could, some of these are fairly long ones as I look at this, but I'll try my best to grab some ones that we can knock off. Question for Teresa, maybe Chris. Some injured employees do not go in person to the doctor for a physical exam, and the appointment is a teleappointment. We're seeing a lot of that now. They provided a patient employee with a take time off, but have never actually seen the employee in person and only have the side of the employee post-COVID. This is not reasonable for work-related claims. The employee should be seen in person, maybe? Question mark. Thoughts?
Yeah, I will go back to what I said initially, and that's that if you are registering a file with WorkSafeBC, have them call teleclaims, get that number and send them to physio. You get that one free physio visit, so you're gonna get all the functional information that you need. And then second, we do not need medical information to make an offer of suitable work. So maybe, as was suggested before, we're erring on the safest, lightest ability for that person to go back to work, but making that offer. I've seen my doctor plenty of times via phone, and we have a relationship, and I could see her asking me, what do you think you can do? Nothing, and she'd probably support it. But if I gave her a functional abilities form that I received from physio, well, she's gonna err to the side of the physio because they understand that they've spent time testing what my abilities are. So getting them into physio can be really helpful and can give you information you need. But if not, don't be deterred from having that conversation. Even if the doctor is saying 6 months off, don't be deterred. Have the conversation, find suitable work, upload that document onto WorkSafeBC. You agree, Chris?
Yeah, I agree with all that. And the other thing to just kind of query is that, is it part of the worker's duty to cooperate to provide medical information that can actually be properly assessed. So I don't know how far the duty goes and whether we could say that we could require them to go in person to get a proper assessment, or require them to get a note that says more than just 3 months off work/school. But you always have that ability to lodge a complaint that the worker's not fulfilling a duty to cooperate if they're delaying in getting you that information. I mean, that may be an avenue. I just don't know if it's been explored and where the board's going to come down on that.
I know that we have also provided workers with the modified duties list directly, and we've had some success where we're able to prove that an employer, handed them the full list of modified work that's available. And I'm on our form, a doctor is required to sign off a worker could or couldn't do this. So in cases where that form has maybe not been returned as quickly as it should be, and it turns out the physician wasn't advised of that, we have had some success at the review and appeal level, and having somebody come back and say, look, the proper information wasn't provided to all parties to make that determination. So I don't think it hurts to give the worker a copy of the modified work or the FAF form, especially if you can prove that you gave it to them, to come back to WCB later on and say, look, they were given all this stuff and we haven't received anything back. It helps to speak to why that obligation isn't happening, I think.
That's great guidance. Thank you, guys. Another one just along that lines with physiotherapists. Are there any services like physiotherapists to come into the workplace, review job requirements, movement, lifting capability of worker? Those assessments on site. Employers can do this, but how do you avoid biases in these assessments? Wondering if WorkSafe has any guidance on this.
Well, there's several different ways you can go. If you have a robust injury management program, we do have a program called EAP, Early Access to Physiotherapy, where a person can be seen within 72 hours at a physio, and they can have copies of modified jobs that you have available. This gives them the opportunity to speak directly to your modified jobs when they are doing a physical assessment. The physios that you go to with EAP, there's multiple physios in the area that they would probably already see. So as long as it's one of our physios that we're contracted with, who they would already see, because that's what you need for a WorkSafeBC claim anyway, then you can have that information provided for you. people coming into your workplace, that can happen later in on a claim. We've had OT and physio come in to assess your workplace, assess a job. But I think for the quicker method of getting there, you getting into physio right away, letting them know that what jobs you have available kind of works. If you're not a part of our early access to physio, nothing stops you if wherever you're located and going and speaking to physio around and saying, hey, could you prioritize us as an employer? We have people who get injured. We'd like to send them over to you. We'd like you to tell us whether or not they can do any type of work or what it is, or give them a form they can take to their doctor. Physios will cooperate with that. And sometimes the workers feel a little bit more, again, confident in going back to work because they're actually being tested to see what they can do. So it gives them a bit more confidence in the ability to do that. So those are some options there. And some employers actually hire their own physio to take a look at the job site to help them find suitable work within their job as well. So you can sometimes contract with a physio clinic to do that for you as well.
Maybe going to Amanda on this, just following up. I mean, is this something that, I mean, obviously, Teresa, you can help with this, WorkSafe can, just guiding, employers around, creating this modified work duties, for employers, because again, we hope that we never have to use it. It's not a great strategy, right? But the idea though is that having something prepared, being ready for it, and is ideal. So Amanda, thoughts on that?
Yeah, 100%. I mean, that's what we do. So we're here to support employers. So some of that may be supporting you with documentation. We now have digital, versions of those things for ease of use. We have virtual physio assessments for immediate use by clients. And clients with us have a dedicated client relationship manager that helps do everything from the time they come on board. So that could be identifying modified duties. It could be, coming up with paper, digital versions of modified duties offers. It could be coming into the work site. It could be even doing supervisor orientations to make sure everything's going. So lots of different options there to help assist with that.
Thank you.
We have a return to work toolkit online. So if you don't have access to an injury disability management program, we do have, if you go to WorkSafeBC.com, our return to work toolkit has sample modified job offers, functional abilities forms, letters for your doctor as well that you can utilize. We encourage you to plagiarize them. Just put your company name on top if you like and use our resources.
Fantastic. That's great. Great guidance. Maybe time for one more question. Teresa, you mentioned that workers can upload these medical and suitable work offers into a portal due to privacy law. One attendee notes that they didn't think that the employer could upload these documents. How do employers get consent to share medical documents with WorkSafeBC?
Well, the medical documents, I would need more information exactly on what it is that you're trying to share medically. When it comes to your suitable work offer, first of all, WorkSafe is a place that can receive confidential information. Your information is just as important to us, and we have an entire department that makes sure that we're receiving things safely. Because the worker can see what you're putting in the portal, if you feel like the information you're putting on is going to cause a problem, but you need it to justify any decision, call us first. We will talk about what you need to redact. We will talk about how to get it to us without it necessarily being on a portal, but call us first so that we can do that. Sometimes our compliance department, in asking people about the duty to maintain employment, have come across confidentiality issues, and they've been able to receive the information differently if that's what's need be. But you are able to upload a suitable job offer. You should have been talking to the person about it, so they should be aware of what it is you're uploading. So that shouldn't necessarily be a problem. But if you find that confidentiality is a problem in that the worker seeing what you're offering or whatever the situation may be, contact us first. And you can, in the portal, send a note to the claim owner saying, I have a suitable job offer I would like to upload, but I would like to discuss with you first. Please give me a call back.
Thank you. That's great. I'm telling you, I can't believe how time flies, and we could continue to go. There's so many questions that I'm just going down. I'm trying to pick, a balanced approach here. I really want to give last thoughts to our panel team here. Chris, any other thoughts around this topic? I know we're going to talk about it again. I can see by the interest that we should. But any final thoughts from yourself first?
Yeah, I mean, I've definitely had a lot of my clients approach me with with a situation where they've got someone that maybe has been having performance issues, or someone that they were kind of gearing up to maybe let go due to misconduct, or even just not being a good fit, and then that person will have a work injury and you know, be off work for a couple of weeks and then come back, and employer will come to me and say, like, you know, are we stuck here? Like, can we proceed with what we were planning, or does this person, are they immune? You know, simply because of the fact they went on a WorkSafe plan. You know, so what I tell them is you can proceed with what you were planning to do, but now you have this kind of hurdle by way of the presumption that's been created, that if you terminate someone within 6 months of them returning to work from a work injury, there's going to be an assumption that it's related to the injury, and it goes back to you as the employer to rebut that with you know, clear objective evidence that your decision had nothing to do with that. So, you know, it's not a free pass if someone gets injured, in terms of, you know, what your plans might have been for that person, but you have an extra layer of caution that you need to exercise. And again, this all goes back to documentation. You know, do you have discipline policies in place where you can show you've been exercising progressive discipline and this was just the final straw? We just followed our policy, it had nothing to do with the work injury, would have happened anyway. You know, have you properly documented the instances of performance or lack of performance or misconduct? Do you have those warning letters in place? You know, just those proper HR practices become crucial when you have a situation where you may have a bad, you know, a bad actor, a bad, you know, a bad apple that you need to terminate for the good of your organization and your morale, and you don't want to end up stuck with you know, a whole bunch of legal complaints. So just that, you know, that documentation piece is crucial, and knowing that it is possible to still go ahead with it. You just have to be careful and you know, maybe get some advice before you go ahead.
Thanks, Chris. A lot of good advice there. Good HR practices, critical for this to not turn into a giant issue for you potentially. Teresa and Amanda, I'm going to give you both very quick seconds before I close off the webinar here. Teresa, go ahead. Final thought.
Thank you so much for allowing me to be here today. Following what Chris said, document. We've said it all through. Make sure you're documenting, make sure you're uploading, and I will provide the information for my department that I work in. If you have any questions on your injury management program, how the obligations to Bill 41 apply to you, call us. Please call us, please email us. We're here to help.
Thank you, Teresa. And Amanda, wrap me up.
Yeah, I mean, lots of stuff going on. I think lots of stuff still to come. I think Chris touched on that. There's a lot of things we're waiting to see how they wash down from WCAT and stuff. So in the meantime, I think, again, document things. If you guys need help, obviously there's lots of resources here. So you can reach out with questions. And I know there's a bunch of questions. I'm seeing them flying last minute here. Happy to answer those or the more specific ones after the fact. And yeah, look forward to moving forward on this. But I think the key here is just communication and documentation.
Again, thank you so much to my panelists, Teresa, Chris, Amanda, again, joining us today. Great wisdom, great information. It really adds a lot of clarity for our members. We're going to share a lot of these unanswered questions today with our guests, so that or the answers to these questions. And we've obviously recorded it today. Education is critical to understand and respond to our changing regulatory requirements. So we'll continue to support you as we can with up-to-date information and resources, and keep you and your programs current. So if you'd like to get more information on this topic, Amanda will be, and our colleague Jen will be here at our Make It Safe event from TeksMed Services on our October 10th Make It Safe Vancouver at the Anvil Center. They will be hosting an interactive workshop to help you manage your occupational disability related processes effectively and saving your businesses time and money. We all need to be looking at that for sure. So we're back at the Anvil Center at the Make It Safe October 9th and 10th this year. And we really hope that you all join us for training and insights to improve your health and safety performance of your organizations. Also this year, Make It Safe Online is included in your tickets. So that is for our October 30th and 31st online event. As well, there are tickets that are sold separately. Our space is starting to fill up and is limited, and our early bird ends tomorrow. So please pick up your tickets today at the best rates available to you for makeitsafe.ca. Again, if your business produces or handles potentially combustible dust, we have a course that we're going to be offering, important steps for you to take and prepare for the new combustible dust regulations coming in 2022. And it does impact a lot of people. So please take a look at our combustible dust course. And if you need more help in developing your combustible dust programs, we offer these assessment services. Please contact one of our safety advisors for support around combustible dust. As always, you can visit us online anytime, or to have access to our webinars or resources, watch for an email tomorrow with a link to the recording for today's session and a survey link to share your important feedback about our webinar today and our programs. So as I leave, please share your thoughts in a quick survey. We really appreciate you joining us today. And from myself and to the rest of our staff, we thank you for joining us, and we hope to see you at Make It Safe in a few weeks' time. So thank you for joining, and have a great day.